Good afternoon.
Good afternoon, Judge.
No.
Sorry for the last minute change. My friend and colleague Paige Whitaker got sworn into the Court of Appeals this afternoon, this morning, I guess at 11, and I realized that about 2 days ago. So that I had a conflict. So I apologize for the delay and the last minute change, and I do appreciate y'all's willingness to pivot on that one quickly. So, Madam Court Reporter, we are going to go on the record in the matter of Reginald Walker et al. Versus CRF Small Business Loan Company and Berkeley Alternative Income Fund. The civil action number is 26 CV 004531. Can I get announcements for the parties, starting with counsel for the plaintiff?
Yes, Judge, my name is Skylar Elliott. I represent the plaintiffs, and my client Kim Betts and Reginald Walker are on this Zoom.
Okay, thank you very much. And for the defense?
Good afternoon, Your Honor. My name is Jeff Hoffmeyer, and I represent CRF Small Business Loan Company, LLC.
Excellent. Okay, so I see there are a few other people on.
Yeah, Your Honor, I'm sorry. Brian Bush, counsel for the defendant Berkeley Alternative Fund. My camera says it's on, but I don't see my picture there. Can you see me?
I do not see you, sir, but I can hear you, which is the important part.
All right.
So a couple of things. This is the first time we're having a hearing, although I understand you guys have been in close contact recently with my staff attorney, Mr. Freehoff. I expect that you will. I know that you will find him to be very responsive. So if anything comes up, you have questions, he's happy to respond and give you guidance about how I will handle things. Couple of things to start with. Number one, this is how I do all of my civil hearings. And so want to make sure you're aware of the fact that this is being live streamed. Now, probably nobody is watching it and probably nobody in the world will ever care about it. But I do want to let you know that in order to satisfy my obligation to have open courts, this matter, when I handle Zoom matters like this, they are live streamed to YouTube so that they can be watched if somebody ever wants to. Now, one reason I mention that is that as an artifact of how Zoom live streams to YouTube and what Google does, that means there will be a video recording of this proceeding. I've had attorneys use it as a reference point. I don't have any problem with that, but I do want to be clear that that is not an official court record. It can't be used for any purpose. You can't create a transcript from it. It just is an artifact of the way Zoom and YouTube and Google all interact with one another. So take care of your court reporter because she's the one that's going to give you an official record. The other thing is this case is, I spent a really more time than I'd care to admit trying to make heads or tails of this case because of the way it got dumped in. Because of course it was a pretty well developed case procedurally already in Gwinnett County before it got transferred here. And so I think my first contact with all of you was that we needed to have a hearing on all the motions. And that's what I spent so much time figuring out was what motions actually are still pending. At some point we sent you guys an email, and admittedly, I think we might have been a little inaccurate about our communication on one of those motions. But I want to see if we can clean up some of those things right now, because in preparing for today's hearing, for example, there is a motion to add Gentian 3716 Gentian Holdings as a party. And at one point in the page 158 of the transcript on the motion for temporary injunction, counsel for the defendant said they didn't object to bringing in 3716 Gentian. But then I see that there is some effort to do discovery to see if there are, and I'm very also, there is at one point some discussion to drop Community Reinvestment Fund as a party. I'll note that the proposed scheduling order y'all sent me over doesn't include them as a party, but I don't still think there is an order in the record dismissing them as a party. If there is, tell me where it is, because I couldn't find it. That doesn't mean it doesn't exist.
I can clarify. Both of those are on me. I believe I was the one who said I didn't object to 3716 Gentian coming in. I represent CRF. Brian Bush represents 3716 Gentian, and I believe he has an opposition. So that's why that motion is still pending, because
Okay.
he doesn't. As
Okay.
far as CRF, there was a problem with the way this, so what happened was, and Skylar and Brian, please correct me if I'm wrong, if I represent something incorrectly. When Mr. Elliott filed this lawsuit, he filed it against CRF, or Community Reinvestment Fund, Inc.,
Mhm.
and CRF Small Business Loan Company, LLC.
Right.
The reason it was in Gwinnett County was because CRF, I refer to them as CRF Inc. and CRF.
Mhm.
CRF Inc. had a registered agent in Gwinnett County.
Right.
We filed a motion to dismiss CRF Inc. because CRF Inc. Was not a party to the case, and asked that the case, because that would deprive the Gwinnett Court of jurisdiction and move it over. The Gwinnett Court did grant the motion to dismiss CRF Inc. and transfer it over.
And
But
that's actually exactly why I was confused, Mr. Hoffmeyer, is that there seems to still be some,
yeah, their
there
only
still
person
seems to
in,
be something of their existence.
the only person that's still in the case, I think it's a clerk's error.
Mhm.
No offense to them, but they listed my client as CRF Inc. on the style of the case, even though they've been dismissed. So
Okay.
the real party in interest for
Is
my
CRF small business?
loan company LLC.
Okay. Yeah.
So that's that. I think that's an error on the clerk's part.
Okay. Well, I think one of the issues is because the case came to us with motions to add and drop parties, our clerk, sometimes it can be frustrating, but they're trying to be very precise. They're never, ever, ever going to change a case caption unless I enter an order that tells them to change that case caption. Or grants an order saying you can add the party, now file an amended complaint that adds that party, and then they'll accept that new caption. So some of what I'm talking about really is just sort of cleaning things up procedurally. And then I know the part that I think we were maybe a little bit imprecise about is I have a standing case management order that says that motions to compel are deemed denied, vacated, won't consider them unless there's a discovery conference. And I'm happy to talk a little bit about that today. But generally speaking, I don't consider motions to compel unless, not even unless or until, generally, I don't consider motions to compel. We have discovery conferences where I enter discovery orders. Or if necessary, I'll enter an order to compel where we have just a complete, failure to participate or comply with an order. But I don't generally, unless it's some unique issue of work product or, privilege or something like that, that y'all need a written record of, maybe for an appeal. I just generally handle those on a much more informal basis. So I apologize if that was not made clear to y'all before you were advised that we were having hearing on all these motions, one of which was, in fairness, the motion to compel Gentian that Mr. Elliott filed. Is that right, sir?
Yes, and one comment, Judge, real quick, on that motion to add 3716, there was no opposition to that, a written opposition, and your order, your standing order says that if there's no opposition, then most likely would be granted. I'm getting very familiar with your standing order, and that I just wanted to bring that to your attention.
Thank you, Mr. Elliott. And again, I think part of the issue of this cleanup that we're doing is just because it came, if this had all happened in regular course in Fulton County, it would have been handled when it was happening. But now we're just playing cleanup a little bit. And it's mostly so that I don't end up having to go back to something that occurred in Gwinnett County a year ago. At least from this point forward, it's our stuff, and I know, what my orders will be. So, in terms of the motion to add Gentian, the reason I mentioned that, Mr. Hoffmeyer, and I do appreciate the context that you gave me, but Gentian isn't a party. And so I understand, and I'll hear from Mr. Bush in a moment. I know he's having some technical difficulties if we need to address that. But I mean, leave typically is freely given. There's a stated basis. There's an amended complaint that seeks to allege, causes of action as alleging that Gentian was, I think, the landlord or maybe an owner of this property. So we'll get into that. But obviously the meat of what we're here about today is the request from CRF that the court vacate an injunction that was entered by the Gwinnett County Superior Court. And I think the sort of flip side of that is very, very recently, I think about 8 days ago, the plaintiff filed a new verified motion for injunction. And so I will start by saying, are we in agreement that the court necessarily needs to, I mean, it seems to me that the court needs to reach the merits of the basis for the injunction, because the rule that's been invoked, 19.1, is that the court needs to review that motion. It shall be reviewed, and thereafter it is either to be reissued or vacated, depending on what my decision is. Are we all in agreement that that's the standard of what the court should be doing procedurally? Mr. Hoffmeyer?
Yes, Your Honor. I would just point out that the emergency motion that Mr. Elliott filed 8 days ago is a different, as asking for further injunctive relief.
Is that the one about the Florida?
Yes, Your Honor.
That's the one about the Florida.
And I can report, I'm not sure if it's been reported to Mr. Elliott or not, but the foreclosure the foreclosure sale that was scheduled for August 6th, the Florida court has entered an order canceling that sale because the Mr. Betts, who's the defendant down in that case, has filed an appeal of the final judgment. And so pending the resolution of that appeal, the court has not really stayed the order, it just canceled, it said the order setting the foreclosure, and I'm not handling that part of it, that's Florida counsel. But they did make us aware that that has been canceled. So there's not a August 6th moving forward anymore. And I would ask if we could maybe we've spent so much time and money briefing these things, that Mr. Elliott, out of a professional courtesy, would withdraw that motion since the relief requested is moot.
Yes. Mr. Elliott, what are your thoughts about that, sir?
Well, I feel like it's going to come back eventually. Because eventually they're going to try to foreclose on a Florida property. So make everyone happy, I don't want it to be misread if I withdraw that. And I'm taking Mr. Hoffmeyer for his word that it's not August 6th, it's August 10th, I believe, in foreclosure in Florida. As long as I have his word on the record that they're not going ahead with foreclosure sale, then I will agree to withdraw the injunction to stop the Florida foreclosure sale.
Well, it sounds to me as if Mr. Hoffmeyer has represented that the court has entered something indicating that the foreclosure sale is not going to go forward. And if that's the case, Mr. Elliott, you could pretty easily file a notice of withdrawal of that motion that says whatever you think it should say based on the representations from counsel, based on an order that I've received. Of course, reserving your rights to rebring it should that matter go forward. But I mean, not for nothing, it's probably not something that you would get. I mean, there's no reason for you not to withdraw it, because unless there's actually a foreclosure pending, there's not an issue of irreparable injury, and the court's unlikely to grant you an injunction to foreclose, or pun, I guess, intended, to prohibit that foreclosure.
And I'm happy to, Florida's a judicial foreclosure state. That case has been going on for longer than this one has been. If the court, Mr. Elliott does not only have to take my word for it, I'll be happy to circulate the order from the Florida court canceling the August 10th sale. So you'll have a record of that.
Okay.
That's fine, Judge. And just for the, we weren't going to hear that today, the Florida issue. I think you wanted to discuss it, but I wasn't prepared today to go full speed on that anyway.
Sure.
So I just wanted
No, I appreciate that. And I think Mr. Hoffmeyer's point, it only got brought up because I said he was, advising the court that the motion itself is not a request to reissue the injunction that was already entered in this case. It's a request for a new injunction. Okay, so Mr. Bush, can you hear me? I know we can't see you, but you've been having some technical difficulties. Are you able to?
I can hear you loud and clear, Judge. I'm working on the video right now, but I can certainly hear you.
Okay. So Mr. Bush, I'm just going to go in order, right? So one of the first matters that was, I mentioned a moment ago, it's docket number 37 in my docket, was a motion to add 3716 Gentian Holdings. I understand there's separately a motion to compel some discovery from Gentian as a non-party. But, currently Gentian is not a party, and the plaintiff has requested permission to file an amended complaint that adds 3716 Gentian as a party. And Mr. Hoffmeyer, on behalf of CRF Small Business Loan, has indicated that he does not object. But I think they indicated, as you were having some technical difficulties, that they believed that you, on behalf of Berkeley, did object. Can you tell me what is the nature of that objection?
Yes, ma'am. So the nature of that objection is that it is both Berkeley's position and Gentian Holdings' position that neither of those parties should be part of this particular case with CRF. Now, certainly, the plaintiffs in this case have a stated claim for wrongful eviction. We're not arguing that is not a legal basis for having a claim. They also have a claim against CRF for breach of contract. Our issue, Your Honor, is that the underlying facts and the claims that are being made here, there is no overlap between the two, and we believe we should be in a separate lawsuit and not part of this CRF suit. So
let me ask you this, Mr. Bush. I am aware, although it's not a matter for today's calendar, but I am aware that you have asked to be severed out and moved to Muskogee County.
Yes, ma'am.
And I guess my question is, if the court how does the addition of Gentian affect that, right? So if the plaintiffs were allowed to add Gentian, would your argument still be that you're allowed to hightail it out of here and go to Muskogee County and be sued independently?
Yes, ma'am. Gentian is the appropriate. Gentian was the owner of the property and was in charge and the landlord, and was basically the one doing the eviction, for lack of a better term, in 2023 when it took place. And so Gentian would certainly take the position that the wrongful foreclosure claim against it is severable, should be severable from the complicated CRF breach of contract, which is now involved in multi-state, litigation, the foreclosure on that. And so Gentian would have the same position as Berkeley in that it's fine. You certainly have a right to sue Gentian for wrongful foreclosure, but joining it as part of this lawsuit is not only against judicial economy and fairness for Berkeley and Gentian, but the appropriate venue for this sort of a tort claim related directly to property would be in Muskogee County, where the eviction took place. And I would add, Your Honor, that Mr. Elliott has amended this lawsuit 4 times, so we're now on the 4th amendment. There is one discrete claim against Berkeley for wrongful eviction. There is one discrete claim against CRF for breach of contract. There are no overlapping legal issues between those two. Now, it is true that Berkeley and or Gentian may potentially be a witness to some of the claims that were made and the defenses in the CRF claim against it for breach of contract. But as far as any sort of legal overlap between the tort claim for wrongful repossession or eviction and breach of contract against CRF, those are completely distinct legal claims, and there's no overlap in the lawsuit, at least the first 4 lawsuits that have been filed, that would show any legal overlap between those two, other than potentially being a witness.
Thank you, Mr. Bush. Just from a logistical perspective, I've reviewed this file a lot, and I only find 3 amended complaints. That doesn't mean that it's not here and just labeled as something different. And it doesn't really matter as much as I just want to be certain that the amended complaint that I'm looking at is the most current and operative one. And of course, saying that it was filed on March the 24th does no good, because basically the entire docket was filed in this case on March the 24th. The one I'm looking at that I was treating as the operative complaint is docket 75 in my docket. And it looks like it was filed in Gwinnett County on October 28th of 2025. Is that the correct operative complaint?
Judge Schuyler Elliott for the plaintiffs. It is index 75 on the Fulton County. It was filed October 28, 25.
Mhm.
And for argument's sake, I do think that's the Fourth Amendment.
Okay.
But
Just
that's the one we're dealing with right now.
right. And I wasn't necessarily correcting Mr. Bush as much as I was making sure I was looking at that I have been looking at the operative complaint that is currently operational. Oh, there's Mr. Bush. Okay. So I have been looking at the right one. That's a good start for me. Mr. Elliott, what response, if any, would you make regarding your efforts to add 3716 Gentian?
Okay, Judge. In all fairness, I need to fill you in on some of the facts. And I do realize this just got dumped on you. And so in
Well, I
2000,
did, just so y'all know, y'all have briefed a lot and I have read them. I mean, I do have an understanding that this involves, an investment opportunity regarding a sky zone and that there was a property. I feel like I have a basic working knowledge of the understanding. The granular stuff, I'm definitely going to need you guys to educate me about, but you don't need to go back to the beginning of time
okay.
of Mr. Walker and Mr. Betts deciding to open a sky zone or an adventure air, whichever one it was. So,
Okay, thank you. So I'll move it up to 2023. So in 2023, my clients owned the whole building that the Sky Zone was located in. The Sky Zone is Suite B as in boy, but they owned the whole building.
mhm.
Inside that the Sky Zone operation, they borrowed several $1 million to build out the place, and they spent $988,000 on equipment, jump zone equipment, office equipment, things of that nature. So we're in 2023, and Berkeley foreclosed on my clients, and then 3716 bought the building in October 26th of 2023. So thereafter, so then Gentine 3716, I'm going to call them 3716, they were trying to find, my clients were still on the property. They stayed in the property until December 8th of 23. And they were going back and forth with Berkeley to work out something, get a lease, or still stay in the property. They had a huge investment involved. So behind my clients' backs, they didn't know any of this. In January of 24, 3716 rented the Sky Zone location to a brand new Sky Zone franchise operator. And this is why the parties have to be together. So January 24th of 24, 3716 sold all of my clients' equipment to the new Sky Zone operator. And so so what we have here is this really case is between 3716 and Berkeley, because they're fighting amongst each other. CRF is saying we were not allowed in the building to do our inspection, appraisals, all that. But then CRF in February of 24 conducted an inspection. And there was another gentleman that was on the screen, Bustello. I see he's off. I don't know if he's with Brian, but he was there at the inspection. So in January of 24, the new Sky Zone guy walks into my client's turnkey Sky Zone operation. 3716 sold him the equipment in January of 24. And that's where this should have all stopped, because CRF has spent a whole year claiming that they rightfully bought the equipment in May of 24. They had nothing to buy or sell in May of 24. So CRF's taken the position, our hands were tied, but on the other hand, they did an inspection. This isn't disputed. This is all true. In the May 29 injunction hearing, Exhibit 29 to the transcript exhibits is the inspection report. It was admitted, no opposition. So all right. So let me move
Right,
it.
but isn't the dispute about the inspection, the sale, whatever? I mean, isn't the issue really, doesn't it just come down to the sale of all of that equipment for what one side argues is a commercially reasonable price of about $13,000. And what the plaintiffs argue was, no, we paid nearly $1 million for all of that equipment. I mean, I understand it might have happened in ways that were procedurally weird to you. I mean, but isn't the ultimate crux of that dispute that your clients believe that it was sold out from under them for an amount that's woefully inadequate for what they spent for it?
Well, that's one of them, but Berkeley in 3716 is taking the position that when 3716 bought the building October 26, that equipment belonged to the builder. This is where 3716 and CRF, they're in bed together. They have to be in the same case. So Berkeley and 3716 have taken a position, no, we didn't have to sell anything. You had nothing to sell. It was our equipment. It came with the foreclosure sale.
Well, let me save you some trouble, Mr. Elliott. So, I mean, generally, I start from a position of the plaintiff is the master of their complaint, and if they want to add a party that they are legally authorized to sue, that they have a cognizable claim against that might or might not survive a dismissal motion, then they can do so. And the rules are pretty clear that you can join them all together. And so you start from a position where I would be inclined to grant generally a motion to add a party, particularly one that seems at least facially to be related. I think it would be helpful if you could address the specific issue that Mr. Bush was saying was the basis for his objection.
Well, he's saying that it should be moved to Muskogee County. That's good for them, and that's convenient.
Well, but I'm not dealing with that issue right now.
Okay.
My question is, I think I asked Mr. Bush, what happens if I let you go, let's say for a moment, for argument's sake, that I were to allow Berkeley to leave the case, to sever them out and go to Muskogee County, where does 3716 Gentian go? Does it stay here in this case with CRF, or does it go with Mr. Bush's client to Muskogee County, for argument's sake?
They would stay here in Fulton County.
Okay.
And I feel very strongly about that because they're an indispensable party, because it's going to boil down to who's on first, who's on third, who was there first. And we can't do that without 3716 in the picture.
Okay, I understand. Mr. Bush, I'd like to ask you for sort of your last thoughts, because
Yes.
you're the one sort of, as I said, I think you start out because of the rules of procedure and the way that law has been interpreted, that the plaintiff is the master of their complaint. And there has to generally be a good reason for me not to allow a plaintiff to amend their complaint to add a party that they, as I said, are asserting they have at least a legally cognizable claim, even if it's going to end up being complicated by the fact that in about 30 days, I'm going to need to consider your motion to sever, and where does Gentian fit in there?
And Gentian would join Berkeley's motion to sever because they're in the exact same spot. So the allegation against both Berkeley and Gentian is that they wrongfully evicted plaintiffs from the space. That's the only legal allegation against
That's
both.
count two of the current operative complaint.
It's count two of, and I think you're right, Your Honor. It was amended complaint 3, the correct date there. But that wrongful eviction claim is the only claim against Berkeley, and what the plaintiff is doing is seeking to add Gentian, who was actually the owner of the property at the time that the eviction took place. So they are probably more properly part of this wrongful eviction case than Berkeley is, since Berkeley had sold the property. So Gentian is going to be in the exact same spot as Berkeley and would be joining that motion to transfer and or sever the case, since the only claim against them is for this wrongful eviction, which has nothing to do with the breach of contract claims that are being litigated between CRF and the plaintiffs.
Okay. Thank you, Mr. Bush.
Thank you, ma'am.
So I don't think I made it a secret. I understand your concerns, Mr. Bush, and I may end up having to retread this water later. But generally speaking, I've not heard anything, given that the current named defendant, CRF, Small Business Loan Company, does not object. I understand the nature of your objection, and again, I may have to sort this all out later. My review is that your motion to sever and transfer was filed on July the 2nd, which means that we will be sorting that out probably sometime in mid-August. What I would be inclined to do is to grant, and the reason I point that timing out is that if I were to enter an order today granting the motion to add 3716 Gentian as a party, then I would probably require that Mr. Elliott do so by a particular date. That would be the beginning of August, that he file an amended complaint naming them by that date. And then that way, the complaint itself would at least be right for us to have a conversation and I'm sorry, not your client, for Gentian to join into that currently pending motion and sort of piggyback onto it. That would be procedurally what I would do. Other than the fact that you substantively disagree with the ruling, any concerns about that procedurally, sir?
No, ma'am, and we could certainly accept service if the court entertains that.
I very much appreciate that. And I
Yeah.
can't make you, but I love it when people do. So
No. We'll accept service and then we'll be joining in the motion and so I understand the court's position there and we'll address the motion to sever and transfer in due course.
okay, thank you so much, Mr. Bush. Okay, so Mr. Elliott, first task, action item that I need from you, if you don't mind, is if you can please send me a proposed order in Word format that allows you to add 3716 Gentian as a party defendant. And what it actually will allow you to do is to file an amended complaint naming them. And it will be on or before, let me look at my calendar. On or before July 31st. And then to the extent, again, I can't make you, but I wish I could, but to the extent that the parties can agree to accept service so that Mr. Bush can procedurally join together those concerns in terms of the request to sever, then the court, it will be procedurally ripe at that point, and the court will deal with it then. Okay, and then the motion to drop Community Reinvestment Fund, Inc. I think we're all in agreement that that motion was either withdrawn or it was granted or something. But what I need to make sure of now is that it is reflected in the docket so that the clerk does not reflect that individual as a party, because they still are listed as a party. And in theory, when it came over from Gwinnett, they shouldn't have been listed as a party anymore because they'd already been dismissed. So I'm probably going to have to enter some sort of order that directs the changing of the case caption. What I will likely do is wait, Mr. Elliott, for you to add 3716, and then I'll do something to sort of clean it up. And then the only thing I'll ask is, I know we all cut and paste, but if I do go to the trouble of correcting the case caption, if you guys could endeavor really hard to make sure you're using the most current case caption when you file stuff, I would really appreciate that.
Judge Krause?
Yes, sir, Mr. Hoffmeyer.
My filing system is not as good as yours or Mr. Elliott's because I don't have them listed by docket number, but I do have them by date number, and the order granting motion to dismiss CRF Inc. as a party is found, it was entered on February 26th of 2026.
So the only thing I have going for me on navigating this docket, because again,
Yeah, when they bring it over, it changes all the titles and everything. And
yes, and all of it looks as if it was entered on March the 24th, which is of course the day it dropped into Fulton County.
I'm happy to shoot that over to Mr. Freehoff if you want me to.
That would be helpful, because I
Do that
know
right
it's in
now.
here. And just so you know, I don't exactly know how you interact with our Odyssey filing system, but there is thank goodness, or else I wouldn't be able to navigate it at all. But there is a docketing system that does provide a chronological order of docketing. And so that's why I'm able to tell you that, that docket that we were just discussing was docket 75. And for example, the order granting plaintiff's motion for emergency injunction, which was entered by the Gwinnett County Court, is docket number 53.
Okay.
And
I
so if
just-
you
I
can
just
figure out
sent
how to
that order.
navigate that in Odyssey, it's there. And if you
Okay,
could
I
send that,
just sent that order over to Mr. Freehoff.
thank you, Mr. Hoffmeyer.
I can't remember
Okay.
if there's dockets numbers on ours. I got added to a case that's been going since 2017 and trying
Mhm.
to find anything in that case. And then inevitably Odyssey craps out halfway through. I'm trying to find some obscure order from believe it or not, I think Peach Court actually is for whatever, I think it's a more efficient, better system to the extent that Georgia decided not to adopt the CMA and buy into CMECF. But anyway, sorry, that's just my gripe.
Yeah, I know. I'm on a couple of committees where they're talking about this supposedly magical new filing system that will be statewide that we will have.
Okay.
It'll be interesting to see how it works.
Yes.
Okay. So, Mr. Freehoff says it's docket 107. He found it for me. Thank you. Okay, yeah, so I do have the order dismissing party, so I will, based on that order, enter something that Community Reinvestment Fund, Inc. should no longer be a party or a part of the case caption. Okay. What does that leave us with on docket number 57? There was a motion to allow discovery as to the proper parties, and it seemed to be whether or not Community Reinvestment or CRF was the right party. Are we all in agreement that that motion is moot?
That's moot, yes.
Okay, thank you. And then what does the motion to compel Gentian in terms of not like, Mr. Bush, do you assume based on your earlier statements that you're going to be representing Gentian?
Yes, ma'am, I am.
And I don't know if you were having technical difficulties or were able to hear me when I was talking about my preferred process about discovery disputes. Before we get into the merits or the meat of that dispute, if we do, is what does my making Gentian a party, how does that change the status or need for the court to sort through the discovery issues? Mr. Elliott?
It's real simple, Judge. So I really think we can nip this in the bud, at least try to today. There's one document, and that's the document in January of 24 with 3716 sold my client's equipment to the new franchise owner. So Mr. Bush, for the most part, he was pretty good at giving me stuff. I think he gave me too much stuff, but it took 90 days before I got anything. But Mr. Bush is the one who sent me that bill of sale dated January of 24. But in that bill of sale, it references another document. And I asked for that document. And I think that document is going to be very beneficial to my client. And I think it's not going to be beneficial at all to CRF and 3716. So I think, and correct me if I'm wrong, Mr. Bush, I think Mr. Bush made an argument that it's a attorney-client privilege or work product, but I don't see how it could be when he already gave me the January 24 bill of sale where they sold the equipment, and it mentions another document within that document. I don't see how that could be attorney-client. I don't see how that could be work product. And I think that document is going to help us a lot moving this case along. I really
What
do.
is it? What is this document? What do you believe it to be?
I think it's going to go into more detail of the sale of the equipment. I just don't want any loose ends. So I think it's going to go into some more detail.
But I mean, what do you actually, is it an Excel spreadsheet? Is it a narrative discussion of the property? Is it a valuation? Like, what is it?
Okay. So the best way I can answer that for you is that new Sky Zone owner sold it to another Sky Zone owner And he entered into an agreement where he sold the equipment to the New Sky Zone owner. So, that's what I'm looking for, is that agreement. He paid, I think the guy paid $50,000 for the present Sky Zone operator. So, I mean, I think it's going to have details in there.
And I assume that you believe it is responsive to some what request for documents or interrogatory regarding the value of the property that was sold or transactions involving the property. Like, what is it responsive to?
It's responsive to, just to dot my i's and cross my t's, that CRF had nothing to sell in May of 24, to dot my i's and cross my t's, that the equipment was already sold in 24, way before that, because that's what's happening here. This is why this case is dragging on and on. They don't want that cat out of the hat. I do. So to answer your question, I don't want to, like, for example, I've never been in front of you before. So I loaded up the docket yesterday with all exhibits.
Mhm.
My paralegals aren't real happy with me.
Yeah, I bet they were
Yeah.
busy yesterday.
I didn't want to take any chances. That's why. And now I know how you operate your court. So I don't want to take any chances. I don't want to be in a trial. I don't want motions filed and it being a missing document. So that's real. I just want to make this a clean case. I want to represent my client zealously. And I don't see why I'm not entitled to that document. I haven't heard a good reason why I'm not.
Okay. Mr. Bush?
I am not sure which document Mr. Elliott is speaking of.
Okay.
You know, we've been over backwards to give him everything that was part of this transaction. I don't know off the top of my head what he's referring to.
Well,
I can-
here's what I think. If you don't know what he's talking about off the top of your head, and I feel like given the posture of the case, what would make sense is, since I'm going to have to touch this case in mid-August anyway to deal with this motion to sever once it is ripe, why don't I just schedule a discovery conference for sometime in mid-August? It will be by Zoom. You can have them taken down if you want. I often don't. And I will issue a ruling, an order afterwards. But if we can have a discovery conference, then perhaps Mr. Bush, you and Mr. Elliott can have a further conversation about whether you actually have satisfied everything he wants, but for this one document, which would make for one, a very quick conversation for me, right? Because then it's just a matter of what's the document, is it responsive, and is there a basis to withhold it? And y'all might resolve that issue on your own without need of further court involvement, would be my thought. What do you think of that, Mr. Bush? What are your thoughts?
No objection to that at all, Your Honor.
Mr. Elliott, is that okay with you, sir?
No, yes, I'm okay with that. I just wanted to point out the latest amended complaint, Exhibit D as in David, is what I'm talking about. But I've been harping on that thing in every single motion I've ever filed. So I don't know how someone could say they don't know what I'm talking about. But yes, I'm okay with that.
Okay. So I am going to plan for a discovery conference. It will be probably the week of August the 3rd. And it will likely be on either Wednesday the 5th or Thursday the 6th. Possibly it could be in the afternoon on the 7th, but we will try and give you guys some lead time in terms of the particular dates. So if there's any, if there's any conflict or something, just let us know and we'll work around. We try to be pretty fluid with that and leave open parts of time to allow us to accommodate discovery hearings and emergency hearings and things like that. Okay. So I think that leaves only the motion to vacate the injunction. Mr. Hoffmeyer, that is your motion, correct, sir?
Yes, Your Honor.
Okay. Go for it, sir.
Okay. I'm going to give an intro to the intro. Is I have the ability to share my screen?
Yes, you do.
Okay, so make sure. Okay, perfect. Okay. I think before I get into it, I think it's helpful for the court to. I appreciate the fact that the court has taken so much time and effort to get on top of this case. I feel it's important for said I understand some of the background, so I might be going into some detail, but if I feel free to hurry me along. But again, my name is Jeff Hoffmeyer, and I represent defendant CRF, Small Business Loan Company, which I refer to as CRF. We are here today asking the court to review and vacate the order entered by the Superior Court of Gwinnett County, which enjoins CRF from exercising its contractual and state law right to foreclose property securing its $2.1 million loan. The Gwinnett Court's error was fundamental in that it focused on whether CRF's prior sale of collateral was commercially reasonable, found that to be an issue, and granted the injunction on that basis. However, the Gwinnett Court failed to analyze loan documents and binding Georgia Supreme Court authority, both of which make commercial reasonableness analysis irrelevant. First, in the loan documents, plaintiffs waived any right to challenge the sale of collateral on the basis of commercial reasonableness or sale price. And second, the Georgia Supreme Court has held that a secured creditor can collect a deficiency even if a prior sale of collateral was commercially unreasonable if the creditor can show that the value of the collateral was less than the indebtedness. CRF presented uncontradicted evidence that the value of the liquidated collateral was at least $1 million less than the remaining indebtedness at the time of sale. Therefore, CRF has a right to pursue its deficiency whether or not its prior collateral sale was commercially reasonable. The fact that the Gwinnett Court ended its analysis at the commercial reasonableness element is an error. And it's important to note that this is not an academic exercise. The Gwinnett Court's order is harming both CRF and the plaintiff. The real properties that CRF seeks to foreclose are losing value by the day, according to regular checks on the website Zillow. This means that when CRF eventually forecloses, it will recover less than it would have a year ago. And this harms the plaintiff because the value of the remaining collateral is nowhere close to sufficient to pay off the deficiency. So plaintiffs will be left with a larger debt burden to shoulder. Therefore, it is critical that the court correct the Gwinnett Court's error and permit CRF to foreclose. Like I said, I appreciate the court has a briefing before it and it has a long history, and the parties are probably far more in the weeds than the court would like. But I believe that a look at the history of how we got here is helpful to understanding why the Gwinnett order is incorrect.
Okay, well, let me, and I'm going to let you do that, I promise. But let me tell you that in my review of the transcript of the hearing, court's order, and your briefing, right, and the legal issues, Mr. Elliott's briefing, the case law cited by the various parties, the one thing that I think I need some education on is I was surprised that why I didn't see a lot of discussion about the plaintiffs having an adequate remedy at law and therefore not being entitled to injunctive relief. And I understand that real estate and foreclosures are unique, and those are the universes in which you can best argue a right to, a unique right to for injunctive or equitable relief. But at the end of the day, I guess I was struggling with. I was surprised that I did not see briefing on that issue in your briefing. And so because of that, I wondered if perhaps there is some unique procedural aspect to this case that I am not thinking of, or some case law that I'm not familiar with that would dispense with that issue.
The case is a strange case. The way that it is pled is it's in the negative, right?
It is
asserting a breach of contract claim for failure to sell something in a commercially reasonable manner. Typically what happens is when someone files suit to establish a deficiency after collateral is sold, and they will defend as a defense on that basis and say that it wasn't commercially reasonable, and then they negotiate, and then they fight over the amount of the indebtedness.
The next logical extension of that as well is that if your client wrongly foreclosed on these properties, then Mr. Elliott's clients would have a cause of action against your clients for wrongful foreclosure.
That would be separate. Yes, Your Honor.
Yes.
The wrongful foreclosure stems from the basis for foreclosure. There's no denial here. I mean, Mr. Betts testified at the hearing. There's documents that there's no dispute that they are in default, that they failed to clear default, and that we're entitled to pursue our remedies. The only dispute is whether we satisfied ourselves in its entirety based on the sale of the trampoline collateral. And part of and this might change, I know, now that Mr. Elliott is filing an amended complaint, but part of the thing is that I don't know how, I've been working on a motion for summary judgment for a while in this case, and it's hard to argue a case in the negative. They're not actually asking for an injunction at the end of the day. They said they're damaged. There's no request for an injunction in their complaint. They're just asking for this injunction in the context of prior to the hearing. And so what they hope to establish, I think, is that the sale was commercially unreasonable, therefore our debt is satisfied. So that wouldn't really be an injunction. That would just be a declaration of sorts that we are no longer entitled. We've been satisfied. We can no longer pursue it. So rather than
But
getting into,
isn't the injunction that they actually have one that prohibited CRF from seeking to foreclose on other properties in satisfaction of the debt?
just on the two here in Georgia.
Right. And so I guess here's what I'm struggling with. If, let's say it's a declaratory judgment action, and what the plaintiffs are actually asking for is a declaration that in fact the sale of the trampoline property was not commercially reasonable, and then some adoption of some case law that's argued by Mr. Elliott that means that the value, if it was commercially unreasonable, then that limits the amount that can be recovered, right? That's some sort of cap.
Mhm.
And in the meantime, CRF had already foreclosed. Let's say it caps the damages at $13,000 because that's what they sold the property for, at 12.8, something like that. And then in the meantime, CRF has foreclosed on one of these properties, and for $400,000.
Mhm.
And then Mr. Elliott, doesn't he then just turn around and say you wrongfully foreclosed for $400,000 when you only owed 13, and that's a claim? All of that is a long way of saying this is what I'm struggling with. Why is it that why are you not arguing that the plaintiffs have an adequate remedy at law, which is to challenge a foreclosure if and when it occurs, and therefore are not entitled to a legal remedy? Because the fact that that's not argued here, or excuse me, an equitable remedy, it made me question if there's some reason that that's not being argued that I just am not familiar with.
I just thought it was simpler to argue it this way. They previously articulated wrongful foreclosure counts in previous iterations of the complaint, and we argued that you can't have a wrongful foreclosure action until there is a wrongful foreclosure, and so
Right.
they withdrew that part of it. And we don't think they have an adequate remedy. We don't think they have a remedy, period. There's no remedy at law or in equity, and so it would just be kind of a academic exercise, especially when there's something so clear as the Supreme Court's order in business development, which says that, unless you that if you sell some collateral for a commercially unreasonable manner, it is presumed that the value of the collateral is equal to the disposed of is equal to the value of the collateral, equal to the indebtedness, unless we rebut that presumption. And we rebutted that presumption at the hearing, and so commercial unreasonableness doesn't matter because, and I can get into it. I've got some evidence on that, but that's basic. It's just so easy. It's just, there's two easy ways of doing it. One, they waived it in the both pre-breach and post-default in their loan documents and in the loan modification. They waived the right to challenge a sale on the basis of commercial reasonableness or for sale price. And the Georgia Supreme Court's business development case says that we can recover deficiency if we prove that our collateral was worth less than the amount. And we did put evidence of that in front of the Gwinnett court, and the court did not address it.
Okay. Well, I mean, the court did address it. The court's ruling in Gwinnett was, and admittedly, I was very confused by it because the court talked about it in terms of the burden on your client. And I'm like, we're on summary judgment and your client is, we're on a TRO motion and your client is the defendant. I'm struggling to find what burden your client would have of any sort.
Correct.
But what the court did say substantively was that the burden was on you to demonstrate that it was commercially reasonable and you had failed to do so, and therefore
correct.
plaintiffs were entitled to an injunction. And
that's my whole point. This whole argument is that doesn't matter. You can assume, for the sake of argument, that the sale was commercially unreasonable and that we should not have sold it for $12,850, which I'll go into why that was a fair price at the end. But look at the only evidence in the case, and I'll get into this, is that they purchased the equipment not for $988,000, as Mr. Elliott says, and I've got an exhibit here on that, but for $645,000. And then it took a ton of money and to install the equipment. But even if you assume that that the value of the property, if he has admitted in discovery that he has no evidence of the value of the property at the time it sold, even if you assume that it was worth the $988,000 that Mr. Elliott claims it was worth, which is not, which it was worth 6 years before when it installed it, that still leaves a deficiency of over $1 million. And I can show you that as well. We put that in front of the court. So at that point, we've overcome our burden under business development, and the commercial reasonableness of the transaction is completely and totally irrelevant because we just assume I just concede.
I think what I'm struggling with, Mr. Hoffmeyer, is that sounds a lot like a lot of substance that will be important in this case as it moves forward.
Mhm.
What I'm struggling with is why am I going to get into the weeds of commercial reasonableness when I have imperfect and short-term evidence in front of me?
Yeah, and you should. I don't think you should, but essentially got her to pre-decide the case before it was there. But again, like I said, we can concede commercial reasonableness, and we still are entitled to enforce our security agreement. And like I said, the urgency, the reason I felt it was so important to get this in front of the court is because we go through and month by month, the value of this property is dropping on Zillow.
Which I didn't think was possible for real property to do, but apparently it is.
It is. I mean, like I've been tracking it, and it's gone down. So that's part of, as just as a side, that's part of why we've had such a hard time getting this case resolved, is because the values of the properties keep fluctuating. But if I can give the court some background, maybe I can. Let me, if the court will permit me, I'll give you a background of the loan, the reason why it was sold the way it was, what actually transpired at the hearing, and I'll show you the evidence that we presented in front of the judge, and then and then show you why the judge's order was incorrect.
Can I just make a comment, Judge? I would object to that. I don't think the purpose of a 19.1 is to try the case on its merits. That's not trying to.
Hey, we're not having a conversation with each other. We're having a conversation with me.
I was.
Mr. Elliott has interrupted, which I admittedly allowed him to do. But his about third word was an objection, so I was going to let him say it. And Mr. Hoffmeyer, if you have an issue with his objection, you can tell me what it is. Go ahead, Mr. Elliott.
Thank you, Judge. Sorry about that if I went out of line. The purpose of this hearing today isn't to have a case, try the case on its merits. So when Mr. Hoffmeyer said, well, I can go back and show you this, this, and that, that's a do-over. That's not the purpose of 19.1. If he wanted to do that, he should have appealed it in Gwinnett County. First of all, this has been laying around for 1 year and 2 months. Why is this coming up now for the first time? But anyway, so no, we're not here to try the case over again. We will eventually after discovery's done and everything, summary judgment motions. But I'm not here today to re-argue. I already did that. I already prevailed. I think it's a sound order from the judge. So the reason my objection is I don't think it's right to retry the merits of this case, because this is the merits of our case. And did you want me to? Well, I wanted to comment about other things Mr. Hoffmeyer said, but I'll do that later.
And you'll have your chance. Like I said, the reason I did not stop you is because what you said was I want to object. And that's a fair reason to interrupt opposing counsel. And I've let you have your say, your piece about how he's approaching this.
Thank you.
Mr. Hoffmeyer, I'm going to let you continue. I will say to Mr. Elliott's point, 19.1 says that the interlocutory order should be reviewed and thereafter reissued or vacated. And so I do think it is fair within limits, because I don't want to go back and reinvent this wheel. As I said, I've read the transcript. I've looked at the evidence that was presented. I have looked at the order that was entered by the court. But I do have to review the order. Mm-hmm. And it's a weird situation because I'm not sitting in judgment of what, is it Judge Williams did in Gwinnett County? Is that her last name? I'm sorry. I'm not sitting in judgment. I'm not a court of appeals as to whether her decision was correct or not. So really the only way for me to consider it is to consider the evidence that she had before her and determine whether I want to adopt her order or if it's not an order that I would adopt if I wish to vacate it, in which case the parties can file whatever motions they want to file and ask me to do anything else.
Correct. Yes, right. And I'm not trying to relitigate. I'm just highlighting a few pieces of evidence that were submitted to help the court with its review. There's very little case law and direction from the court on the procedures for 19.1. I believe it's appropriate to highlight the exhibits that are, and there are only a few. But if is the court okay if I continue?
Mhm.
Okay. So as you said, common interest, which is owned by plaintiffs Betts and Walker, we're going to open a Sky Zone, and in 2018 they borrowed $2.1 million to purchase trampoline equipment, install it, and build out the space. Common interest gave us a security agreement, security interest in the equipment, and we refer to it as the trampoline collateral, even though it does include computers and kitchen equipment. The overwhelming bit of it is trampoline equipment that was installed. Betts and Walker unconditionally guaranteed the loan and provided their real properties in Georgia as collateral. Of the 2.1 million that can you see my screen? Oh,
I
no,
cannot.
you can't see it yet.
Now I can.
Of the 2.1 million that common interest borrowed, it used $654,000 to purchase the equipment. That showed, this is the dispersal log that was provided to the court. It shows the party, the date dispersed, the date approved, the category. And so that was evidence for the court that that's how much it was installed for. The plaintiffs, as you heard Mr. Elliott contend, say that it was purchased for $988,000. And despite his contention that he's not here to retry the case, he did submit evidence that was not before the court, and that he says he's intending to use to prove that the trampoline collateral was used for $988,000, which was in his notice of filing yesterday. And this is that exhibit. To correct the record, this is the application dashboard where Mr. Betts uploaded information, and the $988,000 is taken from this intended use. This is preceding the distribution of the funds. None funds have been dispersed at this point. So $988,000 is what they intended to disperse for the purchase equipment, but in reality, they only dispersed $654,000 for the equipment. So, and then one of the crucial issues that CRF had to contend with was the fact that common interest was leasing this commercial space in which it was installing the trampoline collateral from a third party. So CRF required the landlord and the borrowers to get a landlord waiver, which is here. It was introduced Exhibit 11, and that provides that the landlord and tenant grant landlord the right to enter upon the premises for the purpose of removing collateral from the premises or conducting sales of the collateral on the premises. Without this provision, CRF would have no ability to access its collateral to liquidate it if common interest defaulted on its obligations. However, Betts and Walker later purchased the commercial space from the landlord through their company K&R Business Holdings Corp., which is also a plaintiff. And they almost immediately defaulted on the loan that they used to purchase the building. Their lender, our co-defendant Berkeley Alternative Income Fund 1 LLC, foreclosed, and the purchaser of the property at foreclosure, the potential co-defendant 3716 Gentian, evicted common interest from the premises. This had the effect of making the carefully negotiated landlord waiver unenforceable. And this was unfortunate timing because at roughly the same time in 2023, the obligors also defaulted on their obligations to CRF. The obligors, including common interest Betts and Walker, executed a loan modification agreement, which we put in at Exhibit 12, and this shows that it's between the lender and the parties. And in that, they acknowledged that the loan documents were valid, that there was a default, and that they owed at that time over $1.745 million, which continued to accrue with interest rate, and it does not include lender's costs, expenses, and fees. And they also reaffirmed all that the guarantees remain in full force and effect and are in no way limited or modified by this agreement. Soon after they entered this modification, they defaulted and parties were unable to come to terms on a further modification. So CRF started to make arrangements to recover the trampoline collateral installed in the building, but 3716 Gentian refused to allow CRF to come onto the property. After that hearing, I was given a letter from Mr. Bush, which was exchanged between counsel for, I was not counsel at the time, for 3716 and CRF. And Mr. Bush wrote that, as we have discussed, there are several creditors claiming an interest in the equipment located in the Sky Zone. However, after reviewing all of the competing claims, it is apparent that GH, which is 3716 Gentian, that their interest in the equipment and fixtures is superior to any creditor claim, and GH is not interested in allowing junior lien holders access to the property for an appraisal, auction, or removal of trampoline equipment that is affixed to the property. They then offered to settle it for a one-time payment of $5,000, and they attached it an appraisal from the Dobbins Company. The Dobbins Company said that although the trampoline equipment likely were expensive to purchase and install, they have little value if sold to be removed. The furniture, office equipment value is marginal, and to save a lot of reading, he says overall, his opinion is that if an auction were performed at this location and all the items are sold to the highest bidder, less than $10,000 gross would be recovered. However, when considering the expense of conducting an auction, if an auctioneer could be retained to conduct such a small operation, the net recovery would probably amount to less than $1,000. And there's setup, advertising, checkout, and sales commissions to consider, plus utilities and time. If I were advising a bank client in this situation, I would advise them to abandon the collateral. So CRF at that point had to determine if it wanted to access its collateral. It was looking at an expensive, time-consuming litigation with 3716 Gentian. And so in order to determine whether it was worth it, CRF commissioned its own auctioneer, Grafe Auction, to analyze what its potential recovery would be if it could access it. And this was before the court. This is a report from Grafe Auction that looked at it. And Grafe Auction wrote that we are familiar with selling this type of entertainment equipment. In October 2020, Grafe conducted an auction for Sky Zone location in Noonan, Georgia, and the gross sales were $48,700. He goes on to note that COVID had a big impact on there, and there were items that were not included in the sale. He says, I would estimate that this auction today would yield closer to $60,000 to $65,000 gross, but you will see the estimated cost for Grafe to conduct an auction, which will allow you to establish net proceeds. There is a 15% commission, $1,500 for setup and catalog services, $2,400 for marketing, $3,500 for removal staff. And then he says,
Mr. Hoffmeyer, let me interrupt you for a second.
Sorry.
Here's what I don't understand about this exercise.
Mhm.
This sounds like you're demonstrating to me why your client's actions were commercially reasonable. And I thought you started from a premise of it doesn't matter if it is or not, they're still not entitled to injunctive relief. And if that's your position, then due respect, sir, there will be a time and a place for you to try and persuade me or a fact finder, i.e. a jury, if that's appropriate, that your client's actions were commercially reasonable. I'm just not sure this is the time.
Right. No,
Because-
I agree. That
Okay.
sounds like that. I'm trying to build in the evidence plus the takeaway point is that there's two bits of evidence that were submitted to the court on what the value of the trampoline collateral was. One was this Grafe report that if you take all these numbers and all this information, you take the $60,000 to $65,000 and you deduct all these costs, then the best case scenario is $12,850. There's also a net negative recovery that's possible. So the only evidence in front of the court as to the value of the collateral at the time it was sold is this, which the most is $12,850. We're willing to concede that Mr. Elliott could argue that the $645,000 that they purchased the equipment for 6 years earlier is the value of the collateral, but we dispute that. Anyway, I'll skip ahead. So that's the point of that is that the point of this whole exercise is that they were in default. They don't deny it. We are entitled. They admit that we're entitled to exercise our remedies, and the only basis they have for having us not enforce our remedies is this commercial reasonableness argument. However, as I showed at the hearing, we presented evidence that one other thing that happened at the hearing was that Mr. Betts testified that they made 3 additional payments after the loan agreement, the loan modification. Loan modification, if you recall, said the indebtedness was 1.74 million and some change, plus additional interest and cost. He said he paid 3 additional payments of $15,000, which would reduce that by about 45,000. So call it about 1.7 million, being generous to them. We actually have the actual payoff as of May 22nd of 1.97 million. So at the hearing, we presented this evidence and we made several arguments, as we pointed out in our reply brief, including the fact that Betts and Walker failed to tender the amount owed, which is a requirement for stopping a foreclosure, that they waived their right to challenge a foreclosure as commercial reasonableness, and that the trampoline sold for an amount that was less than the value at the time, so we are entitled to enforce our remedies. But in its order, the court completely ignored these arguments. In its limited analysis, the court merely found that there remains a question as to whether CRF disposed of plaintiff's collateral in a commercially reasonable manner. And as a result of this finding, the court enjoined the foreclosure. But this finding is not correct, because in light of the evidence submitted, the issue of commercial reasonableness, which the entire ruling hinged on, is completely irrelevant. First, as we've shown, Betts and Walker waived their ability to challenge a sale of collateral. We've submitted this guarantee of Mr. Betts, and in the rights notices defense of guarantor waives, it said guarantor waives defenses based upon any claim that lender did not conduct a commercially reasonable sale and lender did not obtain the fair market value of the collateral. After they defaulted, they signed the loan modification agreement, which affirmed these provisions. So given these provisions, they're not able to challenge the commercial reasonableness. So the court's finding that there's a fact issue on commercial reasonableness doesn't matter. Second, and more importantly, and as we kind of belabored in our reply brief, creditors in Georgia can still recover deficiencies, including by foreclosing on collateral, even where prior sales of collateral are commercially unreasonable. In the Business Development Corp of Georgia case, which is 261 Georgia 886, it says, if the creditor conducts a commercially unreasonable sale and does not rebut the presumption that the value of the collateral is equal to the indebtedness, he loses the right to recover the deficiency against debtor and guarantor. If the presumption is rebutted, the right to recover the deficiency remains. And here, we rebutted the presumption. What it means in this, what Business Development Corp says, I suggest to the court, is that even if the sale is commercially unreasonable, even if we grant what the judge, what Judge Williams found, which is that there is a fact issue as to commercial reasonableness, it does not justify stopping a foreclosure because CRF can recover its deficiency based on the evidence. CRF rebutted the presumption. It submitted evidence that the indebtedness was over 1.7. I just showed you it was actually closer to 2 million. Meanwhile, the evidence CRF submitted shows the trampoline collateral was worth at most $12,850. Plaintiffs submitted no evidence of what the trampoline collateral value was, and plaintiffs admit in their discovery that they have no such evidence. CRF even went so far at the hearing to say, well, let's assume that CRF sold that when they sold the trampoline collateral, it was worth the $988,000 that plaintiffs alleged they paid for it 4 years ago, but that is still $1 million less than the $2 million they owed. So in the face of such a showing by CRF and the failure to rebut it in any way, shape, or form by the plaintiffs, the Gwinnett Court should have rather concluded that the trampoline collateral was not equal in value to the amount of indebtedness, ruled that CRF could still pursue its deficiency, and denied the request for an injunction. So, and I'll conclude here, is there's 2 bases for why we should get relief from this order, and that's because it's 100% contingent on the court's finding that there was a fact issue as to commercial reasonableness. However, Betts and Walker contractually waived their ability to challenge commercial reasonableness of a sale, and we've rebutted the presumption that with evidence and uncontested evidence that the value of the collateral at the time of the foreclosure greatly was much less than the overall indebtedness. And so under the Supreme Court precedent, we have the right to recover our deficiency. So the court the court's finding that there's a fact issue is completely irrelevant, and it is the basis of a flawed order. And like I said at the beginning, the court has order has harmed both CRF and the plaintiffs. The property is depreciating, and we are, the plaintiffs will have a larger unsecured amount that they're going to have to pay. They're going to be saddled with. We're going to recover less. And so we think that based on this kind of, based on the risk of further depreciation, the court should take a hard look at this ruling and find that the court got it wrong and vacate the order and allow us to proceed with foreclosing the property. And we appreciate the court's consideration.
Thank you, Mr. Hoffmeyer. Can you take down your screen share, please?
I sure can.
Thank you. Mr. Elliott?
I'll try to keep it brief, Your Honor. That's not what happened on May 29. First of all, CRF had the opportunity. They didn't bring any witnesses. They had the opportunity to do everything they're trying to do today then.
Well, Mr. Elliott, due respect, this is really the struggle I'm having with the order that was entered, and the discussion that we've been having is why was Mr. Hoffmeyer's client obligated to bring any witnesses?
Okay.
I mean, you were the one seeking injunctive relief, and you had an obligation to present evidence to satisfy the elements of the necessity of injunctive relief.
Okay. Fair enough. So I'll just stick to my side of the story. First of all, injunctions are issued all the time to stop foreclosures. I probably have dozens of them pending at one time or another in Gwinnett County. First of all, the damages are not liquidated. Mr. Hoffman keeps talking about liquidated damages. We cannot determine liquidated damages until we determine if the equipment was sold in a commercially reasonable manner. Mr. Hoffman keeps throwing out $2 million. It's not $2 million. When this whole fiasco started, it was much less. It has greatly gone up because of attorney fees fighting over this darn equipment issue. If we had just dealt with this from the beginning, we wouldn't be here at this point. So anyway, there is no liquidated damages as you and I talk. First, as far as waiver goes, we've already briefed this. This was brought up at the hearing. Georgia UCC law trumps this waiving your rights and everything. This is very clear Georgia law that you can't waive your rights. I understand it says that, but Georgia says you cannot do that. This is brief. This is on the record, all these briefings. So that's a complete misrepresentation of the law. If that was the case, it's not the case. So as far as there's no liquidated damages. The judge granted the injunction because she saw that there would be irreparable harm to let CRF go ahead with a foreclosure sale where they didn't have all the facts in front of the court to determine that. And that's why I said
No, go ahead.
And so no, that's where we're at. It was a sound. The injunction is proper. I understand you can always pick apart Monday morning quarterbacking someone else's order or someone's, but bottom line is we were there, we proved our case, hence the order. And nothing has been disproven since then. I know Mr. Hoffmeyer is trying to say, well, they should have considered this, they should have considered, no, they considered everything they had to by law to grant the injunction. They considered the fact that Georgia law, UCC law trumps this waiver stuff. I mean, the judge considered that. She also considered that she heard testimony from my client, Kim Betts, that there was no sale, that there couldn't be any commercial reasonability. So I think that's why the judge said that. That's an issue to be determined. And I think you honed in on that too, that needs to be decided by the trier of facts. But to stick to the injunction, why it should stay intact is because it's proper. Injunctions are issued all the time when someone will suffer irreparable harm. It isn't $2 million. That's a fictitious number. That's just and it hasn't been proven. Nothing's been proven as we sit here and talk. There's been no depositions. There's been nothing proven on what is owed, if anything is owed. So I guess we can anyone could pick apart anyone's order, but
Well, and I don't relish this role, right?
I understand.
Because,
I understand.
I have great respect for my colleagues in Gwinnett County. And, but I will say, and I've not made a secret of it, I am struggling with some of the language that was used in the order, because when you say things like, there's a dispute of fact about something, that's a summary judgment standard. That has nothing to do with a TRO. When you say things like the defendant failed to provide proper evidence of commercial reasonableness of the sale, that feels pretty premature at the stage. And here's, in just all frankness, Mr. Elliott, here's what I'm struggling with. When I look at the elements of a TRO, what I am wondering and what I am struggling with is, I don't understand where the risk of irreparable injury is here. And the reason that I don't understand that is that if CRF were to go forward with the foreclosure and you were able to demonstrate that it was a wrongful foreclosure, your clients would have a cause of action for wrongful foreclosure, which would result in money damages. And generally speaking, if there's an adequate remedy at law, i.e. a claim for money damages, then you don't get injunctive relief. It's sort of where I started with Mr. Hoffmeyer. It's where I'm coming to with you as well. That's the part I'm struggling with. Is where is the irreparable injury if these properties, if they were in fact wrongfully foreclosed, there could be, as I said, a cause of action for wrongful foreclosure, which means there's a remedy in the form of money damages. And that's what I'm struggling with in terms of why I feel like this order skipped over that part and reached out and grabbed the substance of the case when maybe it didn't have to, or maybe the fact that she reached out and grabbed the substance means she assumed, and she does state that there is a risk of immediate and irreparable injury, but she doesn't address this issue that it is not irreparable injury if there is an adequate remedy at law. That's the part I'm struggling with, Mr. Elliott.
Okay, and I understand. I appreciate you zooming in on that. We don't, first of all, whether this is in default or not is disputed. It hasn't been decided by a court of law that they're in default. I mean, Mr. Hoffmeyer talked about some discovery, but that was talked about differently at the last hearing. So it has not been decided what is owed. Actually, right now, as we sit here, there is nothing owed. Nothing. So what are you foreclosing on? But that's like putting a cart in front of the horse, saying, well, let them foreclose and then you can sue them for damages. But what are they?
Well, hang on. As I understand it, what they're foreclosing on is two specifically identified pieces of property that were listed as collateral as part of or associated with personal guarantees from Mr. Walker and Mr. Betts that were part of this loan agreement.
Correct. But in order to enact that, Georgia law, all foreclosure sales must be exercised fairly. You can't exercise a foreclosure sale fairly. I've had that statute in front of me a million times and I just went blank. 23 something 114. You cannot conduct a foreclosure sale fairly. It's an equitable remedy that we're asking for with an injunction. You can't. So that's why injunction proper. They would be, okay, let's assume it is a wrongful foreclosure. Why should we do it backwards? Let them sell their homes and then argue. It's like being on a ship and then jumping in the water and trying to get back on the ship. There is no establishment right now that there's a default, what the dollar amount is, and it is irreparable. You can take these people's homes away from them. We don't even know if we sit here right now if they're in default.
Forgive me if I don't know if this is accurate, but my understanding of at least some of the facts that were represented is that this is not the primary residence of either Mr. Walker or Mr. Betts. These are investment rental properties.
That's correct. I would agree
Okay.
with that.
Okay.
Mr. Betts and Mr. Walker, would you agree with that?
They don't seem to, just visually. I'm not calling on them right now to
Okay,
speak.
that's
They're not
good. I just wanted to make
testifying,
sure I
but
didn't misspeak. That's
No.
my understanding. They're
Oh, these are our primary property that they're trying to foreclose on.
I understand, Mr. Walker. Thank you.
Okay.
As I said, all I know is that from the briefing that I reviewed, there was at least an assertion that these were not the primary residences of these individuals, that they don't live there, which would add, if they live there as a primary residence, that would add a different layer to any effort to foreclose on them. But so I was only pointing out, I don't have that information in front of me, but that is at least an assertion that I saw in the briefing.
Okay, so like you said, we don't have that. That hasn't been proven yet. It hasn't been put into evidence. But what's the difference if it's primary or not primary? It's a foreclosure sale. You still have to follow Georgia non-judicial foreclosure law. It still has to be done in good faith. You just can't yank someone's home away from them, whether it's primary or not. It's real estate. So it's just, you said irreparable harm. We don't even know what they're owed. That's like letting someone take an action first and then we'll ask questions later. And that's it. So I would like for us to be able to do more discovery, get you some of the answers that you brought up, some of the issues you brought up, leave the injunction intact, and just let's develop this more. Let them prove if there's anything owed. You know, let's brief this more. But so to answer your question about irreparable harm, it really the only adequate remedy in law right now, because they want to save their asset. They don't want to. You can't get back on the ship when you're in the water. That's a very, very hard task. So I mean, that's the whole purpose of an injunction, is to stop someone when there's uncertainty, to stop someone that something that you can't reverse. I mean, that would be. Let's suppose that we did prevail at the end of the day. That's just, then they got to go ahead and turn around and sue CRF for money damages. It just, to me, that's just, that's reverse, but we haven't been there yet in this litigation. No deposition's been taken. You know, it's just too, it's not right right now to deal with this. But if it is right to deal with it, everything I said, I stand by. And especially the fact that CRF cannot waive someone's rights. There is no liquidated damages. So what are they going to do? They're going to go to the courthouse steps and say, hear ye, by virtue of sale, we're going to foreclose on this because there's XYZ owed. There is no breach. When you foreclose on a piece of property, it's got to be, you're behind on something. It has to be a dollar amount. We don't know what that dollar amount is. We don't know what they're behind. That's disputed right now. I do a lot of.
Isn't the only reason, so I think not the dollars and cents, but isn't the only reason that it's disputed? I mean, Mr. Walker and Mr. Betts' company took out a loan. They borrowed X amount of dollars. Somebody can tell me what that number is. There's interest that accrued. They made payments that would have reduced the amount owed. And at some point, they stopped making payments on that loan. And so that's a knowable figure. There's apparently a demonstrable default, theoretically, on that loan. And isn't the only reason we're having this, that there's any dispute about what's owed or if there is something owed, because of the plaintiff's argument that it really should only be this $12,000 amount instead of this $2 million amount?
No, they're all tied together. You know, something has to cause, someone has to give you a right to invoke the power of sale on a security deed to foreclose. That's contested right now. So, and I understand what you're saying, but that's putting it in black and white. Well, there was a default, therefore they can do this. No, CRF had their duty to do things right before they can try to collect their money. And so, like, let's suppose Mr. Hoffmeyer threw out some numbers. Let's suppose he gave us credit for $1 million worth of equipment. I don't even think there's any money left. There were other partners that paid CRF money to settle this. We're not even hearing about that. My clients gave Mr. Hoffmeyer $10,000 to stop a foreclosure sale. So we just don't have all the facts in front of us. It's just jumping to a conclusion. But with Georgia foreclosure law, if you send the lender a request for the money owed and they can't give that to you, they have to stop the sale. They have to, and they do it all day long. Right now, as we sit here, there are not enough clear facts on the table of what is owed, what isn't owed. Can they do this? Can they do that? I understand what you're saying, but people stop making their mortgage payments all the time, but that doesn't mean the lender can come in and take the house away from them.
Yeah, it does. I mean, it takes a long time and there's a process that has to be followed, but absolutely, that's a lender's remedy when you stop making payments on your house, is they come take it.
Not if the lender did something wrong and not as if there's dispute. I have 2 Court of Appeal cases on this that for wrongful foreclosures. They're landmark cases, Bank of America, Reset versus Bank of America and Royalston versus Bank of America go into great detail. So no, Judge, I'd be out of business if a lender could just say, hey, you missed a payment, we're taking your house away. It doesn't work like that.
Well, of course not. I mean, there's
Okay.
a process that has to follow, and certainly most lenders wait they wait a good while before they actually undertake a foreclosure process. But nonetheless, go ahead.
So now, I think I said everything I have to say. I'm real adamant about Georgia foreclosure law has to be conducted properly. I may not be able to argue this in Florida because it's a judicial foreclosure state, but Georgia doesn't require much of a lender. Georgia is a pro-creditor state, but what they do require, they have to abide by. And it has to be conducted in good faith. It has to be conducted fairly. How could we possibly say a foreclosure sale could be conducted fairly when we have all these disputes going on and these disputed facts? First of all, half the things that were said on behalf of CRF, they hadn't been admitted into evidence. They hadn't been authenticated. I mean, but to get to your question, can a lender, because someone misses a payment, foreclose? No. My family, I couldn't send my kids to college. We wouldn't be eating at night if that was the law. It's not the law. It has to be exercised fairly. And also, we're asking for an equitable remedy. CRF doesn't have any right to argue. We're saying they don't have clean hands coming into this. So, who are they to say we're doing this wrong? I don't want to. The bottom line is, Judge, I feel very adamant. Maybe the injunction order that was issued has some nuances. But it has enough in there, the reason why it was granted. We're still unsure as we sit here today. And, to pull the plug, that's a very drastic measure. I think that's the whole reason for an injunction is the status quo, slow down. All we're asking for is to slow down before you make a decision. Get all the facts. And there are some facts that are going to come out that are very favorable to the plaintiffs. So anyway, I don't want to ramble. I just ask if you keep the injunction in order. I think I said enough to prove that, and that's what I'm asking you to do, Judge.
Okay. Mr. Hoffmeyer, it's your motion, so I'm going to give you the last word, sir.
Appreciate Your Honor. I think Your Honor nailed it on the head. There's the reason we're challenging this order is because it on its face does not make sense. And there are some very extreme errors that have resulted from it, as I've laid it out before you. But your question to Mr. Elliott was, why was this order correct? And you've got a classic case of, don't have the law, bang the facts, don't have the facts, bang the law. If you don't have either, then you bang the table. It's a classic bang the table. His first argument was, injunctions happen all the time. Well, you have to justify having an injunction. He says there's no liquidated damages. We're not talking about liquidated damages. His clients signed, and I'll put it back up here. His client signed, this is an evidence, contrary to what he said, signed a loan modification agreement. This was, I'll run down here and show you the signatures. They were signed by Mr. Walker. They were signed by Mr. Betts. And in that, they signed and they said, this is in consideration of the recitals and mutual covenants. They acknowledged that the agreements are valid. They acknowledged that they were in default, and they acknowledged that as of May 24th, 2023, they owed $1.745 million and they have interest that accrues. When he was asked about this at the hearing, Mr. Betts said, yes, that's exactly what happens. And I said, well, did you make any payments after that? And so essentially what we're having to show at the hearing is we're trying to show that the amount of the indebtedness at the time that they foreclosed exceeded the amount of the value of the trampoline collateral. And so we've got, a year before with interest and everything, 1.745. I asked him, when was the last payment you made? He said September 2023. Do you know how much those three payments totaled? $15,000 each. So if you reduce the $1.745 million by the $45,000 he paid, including interest, there was evidence presented showing a likelihood of success on the merits. We have to prove it. We have to show a likelihood of success on the merits that he had indebtedness of at least $1.7 million as of the time this was sold, like 6 months later. And it comes to find out that in fact, this is the calculation of the indebtedness as of the date that the property was allegedly sold. And it was 1.973 million. So that is not subject to be, they've not presented a single bit of evidence to say that these calculations are the amounts they admitted to in the loan modification are incorrect. They have not submitted any evidence showing how much the property is worth. And he's made a blatantly false statement. He said that they paid $10,000 to stop the foreclosures. That's blatantly false. We had set these, CRF has set these properties for foreclosure, I can't remember, 3, 4, 5 times. I'll say as few as 3, as many as 5. And every time they said, we're trying to work something out with and got evidence of this in the record. They've asked repeatedly for us to continue the foreclosure. And we said, yes, please pay us the cost of this. General lender practice is we will cancel the foreclosure. We just ask you to pay the cost of re-advertising. Every single time they said no. But we still canceled. We said, okay, fine, we'll continue to negotiate. We'll continue to negotiate. We will cancel these. We won't make you pay it. So his statement is false. There's no evidence to support his assertion that there was $10,000 paid. The only evidence that there was any reduction is this comment by, or this testimony by Mr. Betts that he made 3 payments of $15,000 each. So we're not talking liquidated damages. We don't have to prove our damages. All we have to show is that at the time, that there's a substantial likelihood that we will prove that at the time the property, the trampoline collateral was foreclosed, the value of the trampoline collateral was not equal to or was less than the amount of the indebtedness. And we have shown that there's a very strong likelihood they're going to prove that the indebtedness was $1.7 million or more. You move on to the other side of that equation of, well, how much was the property worth? We submitted evidence that it was worth $12,850. They submitted no evidence. Mr. Elliott even admits, or sorry, not Mr. Elliott, but Mr. Walker and Mr. Betts admit in their discovery responses, which we attached to the complaint. And I apologize for having to attach too many of those, but as you see, typically the professional responsibilities require us to put the question and then what we're responding to, so you don't have to go back and forth and back and forth. But Mr. Elliott's practice is not to do that. So I had to attach all of our discovery requests and then his recovery responses so you could compare them. That's why that file is so large. But we asked them for the evidence of what the property was worth in May 2024, and his response was none. So they have no evidence as to what the value of the collateral is at that time. So why do we have to wait until we win this case to be able to foreclose on these properties? We have shown that we have a substantial likelihood of showing that the value of the collateral was significantly less than the amount of the indebtedness owed at the time. Therefore, we are entitled to enforce our contractual remedies. And another thing he said, I believe he said that there's no way to exercise the power of sale under a deed of foreclosure, so under a security deed in good faith, which I'm just going to pass over that entirely. But he says we didn't follow the proper procedures. What are the proper procedures for a foreclosure sale? You advertise it for 4 weeks in the organ of record for the county in which the property is located. Every single time we went to foreclose it, we advertised in the organ of record for Fulton County for 4 weeks ahead of the sale. That's how they found out about the foreclosures. So we did follow the procedures. The only thing that has stopped them is his insistence on trying to make us somehow to flip the burden on us to prove that the sale was commercially reasonable when that isn't even the basis for it. And I'm going to make sure that I have. He says that we've already briefed the issue of waiver. We did brief that. He argued that in cited case law that I agreed was on point, that pre-contract or pre-default waivers of
Are invalid under Georgia law.
right. But
just as
post-default,
yes,
but
go ahead.
post-default waivers are enforceable, and that's what the loan modification provided. They said, look, these are all enforceable. We're reaffirming everything that's said in the original loan document. So that doesn't apply as well. I'm trying to make sure I've got all of his. Again, he said that there was evidence in the record, but we have emails from prior counsel. We have their testimony on the stand that these were not their personal residences. These are rental properties. That is in the record, contrary to what Mr. Elliott said. If you relied on Mr. Elliott for the record, you will have a very imprecise idea of what is in the record, because it is constantly being, well, I'm sorry, I strike that. So I think the court nailed it. This is the court below. And no disrespect to Judge Williams or to the Gwinnett County bench or to any of them. Sometimes I clerked for Judge Treadwell in the Middle District. I tried my hardest as a law clerk to try to make sure that the judge got the right decisions. We got to return on appeal. We got to return on review. We don't always get things right. We try to as much as possible when you're writing an order, but sometimes you mess up. And here is a situation where it's clear from the face of the document. This isn't a thing where the court set out the findings and said this, it appears that Betts and Walker and Common Interest have a substantial likelihood of success on the merits of showing that that CRF breached the contract or the loan documents by failing to conduct a commercially reasonable sale, and therefore, there's a substantial likelihood. They didn't find that. She didn't find that. She said that we hadn't proven that there was a commercially reasonable sale. And that's, like you said, that is a completely backwards standard on the very face of the order. And if it was just an error that was on the face of it, arguably you can let it go. But because it has the impact that it does, we believe that this is a clear case for the court to step in and correct the record of an improper order. The last thing I'll say, which might have actually slipped out of my head because I was thinking about it as I was making that last argument, is I think we've kind of belabored the point. Again, commercial reasonableness is a red herring when there is evidence in the record that the deficiency is significantly greater. The amount of indebtedness is significantly greater than the value of the collateral, and therefore, even if it was commercially unreasonable, we're entitled to enforce our deficiency. The order is erroneous on its face. It should be corrected, and we should be permitted to move forward. And we will, of course, have a trial. I'm confident we will prevail. And then if we foreclose, then, if they believe that it was improper, then they have a remedy at law, which is to sue us. But there's no basis for an injunction in this case, and we respectfully request the court to vacate the order and order that we can move forward with our foreclosure.
Okay.
We appreciate the court's attention to this matter today. I know it is very long, and I talked too fast, so I apologize to the court reporter.
Yeah, you should definitely apologize to the court reporter.
Hey, I've been working on it. The last time I had this, I've started going to speech therapy just because of how mad the previous court reporter got at me when I was making the argument. So believe it or not, I'm actually slower than I was a year ago when we had this hearing. Not a year ago.
Mr. Hoffmeyer, can you take down your screen share, please?
I always forget that. I'm sorry.
That's okay. Yeah, I was trained. I also am a reformed fast talker. And when I got to be a judge, I had a court reporter who just looked at me like, no, you can't do that. You have to stop. And so
What did you do?
just talked entirely too fast. And you would
I
think,
mean, what did you do to fix it?
I just have to consciously stop and make myself speak more slowly.
You're way more better at it than I am.
Mr. Elliott, your clients are signaling at me as if they wish to be heard in some way. My general practice is to hear from lawyers when there are represented parties. But if you want me to take a break briefly and let you consult with your clients and see if there's anything you want to add, I'm happy to let you do that.
Sure, let me do that.
Okay. It is 2:46. We can be in recess for maybe 5-10 minutes until about 2:56, and then we'll reconvene. Okay.
Thank you. Kim, were you going to call me?
Hey, Skylar, you're not muted.
Okay, I'm sorry.
No, no, no. I don't want to hear. I don't want to hear your conversation.
Gotcha.
So
Thank
go
you.
ahead and mute it so we don't hear any privileged conversation. Sorry, I just want to mention that
Okay, so you are on the,
we're all on here.
all right, so I'll talk to them on the phone. Reggie, can you guys, oh, they're not even on. All right, I'll call them. Thanks.
Yeah, mute your screen, Skylar. There you go.
Thank you.
Mr. Elliott,
Yes, Judge.
did you have a chance to talk with your client? And if so, is there anything that you wanted to add, sir?
Oh, let me take a deep breath here. I did have a time to talk to them. I just want to say one thing, that nothing I talked to them about, but the way I read the law is that if you can't prove that something's been sold commercially reasonable, and in my opinion is it has not been proven yet, then the debt is assumed satisfied. So until CFR steps up to the plate and proves to a court of law that they sold the equipment properly, then then there is no money owed, because they may not owe anything. And I just wanted to point out one more thing and I'm done. Under OCGA 119610, it says that the disposition of collateral, including the method, manner, time, place, and other terms, must be commercially reasonable. None of that has been admitted into evidence. None. There's been no testimony, nothing. So, that's my position. But what I'm gathering is it might be two difference of opinions. One person might say, it doesn't matter. You don't have to sell it commercially reasonable. You can foreclose on it. I don't think that's one way to look at it. I think the judge did in Gwinnett is she said, no. It's so easy to take someone's house away. Let's get this all resolved first before we do that. And that's the whole purpose, is to keep them in their status quo. I think that we should move on. We should have our discovery conference in August, because I have some stuff I want to share with the court. I've never been in this position before. Something was shared to me from the other lawyers, and I just got to figure out how to share that with the court, because it's not favorable to them.
Colonel, before we move on, I didn't think that we provided him for weeks. Can I respond to what he just
I
said?
didn't wasn't talking to you.
Hey, guys,
I wasn't talking.
again, we're not having a conversation with each other.
I'm asking you,
We're-
I'm objecting to and asking.
Okay,
you to-
well then start with the word objection or something.
I said Your Honor. I'm sorry.
And and Mr. Elliott, don't respond. Mr. Hoffmeyer, what was your objection, sir?
My objection is that this has happened before. Mr. Elliott misstated the Georgia law, and he says that there's no debt owed if you don't sell it commercially reasonably.
Hey guys, I have Westlaw.
I know.
I will look
But-
at the law, and I
but
will
I'm-
feel confident when I rule that I'm ruling based on correct law. I
Right,
promise.
but I feel like I should have the last word. He used this opportunity to.
I intended to let you have the last word, but then you interrupted to say
sorry.
objection, which you're entitled to do, and tell me what the basis of your objection is. And then basically, I think anybody who appears in front of me can tell you that one of the sentences I say routinely is, it's your motion, so you get the last word. And because I was letting Mr. Elliott speak again, I'm going to call on you and ask you if you would like to respond to what he is pointing out.
Yes, Your Honor. I'm sorry. I'm
Okay.
objecting to moving on to the discovery conference period of it before I have a chance to make my statement.
Understood. Mr. Elliott, what were you saying, sir?
I would like you to hold off on our ruling until we have the discovery conference.
Okay. Well, I'm planning to take it under advisement anyway. And the extent to which, I'll hear from Mr. Hoffmeyer on that issue, if that's your last thing you were going to say, Mr. Elliott, but the extent to which the court might consider holding off on actually issuing a ruling with a, written order until after August the 6th or 7th, whenever it is that we were talking, 4th, 5th, 6th or 7th, that we were talking about having a discovery conference, although that discovery conference would be, unless there are other discovery issues the parties need to address with the court. My understanding is I was expecting that discovery conference to be relative to the non-party request to Gentian. And so if that's something that, if there are other issues, then the parties need to follow. I'm happy to set aside the time to sort through all of it. But if there are other issues related to the completeness or satisfactoriness to the respective parties about the scope and scale of discovery, then you would need to email Mr. Freehoff and say, hey, look, we need the court's involvement in this person's discovery responses to these requests for production or whatever. I don't want a motion to compel because I don't want you to spend multiple hours drafting the motion to compel. But I do still need some guidance. And so right now, the discovery conference that I'm planning to give you is relative to the sufficiency of Gentian's responses to non-party discovery. And so if there are other issues that the parties want to discuss at that discovery conference, then you'll need to email Mr. Freehoff and let me know that there's an ongoing discovery dispute that needs to be addressed at that time.
Can I ask something about protocol? Because
Yes, sir.
there is going to be a discovery conference. Do we provide Mr. Freehoff with what we're objecting to and our paperwork and everything?
Yes, I mean, I need some context
Okay.
for the request that was made, the response that you think is inadequate.
Okay.
But the idea is let's have a conference where I can say, I think I agree with this party and that answer is insufficient. I'm going to need a better answer before we actually get down into the weeds of lengthy and involved discovery practice, motion practice, because it just takes up a lot of time and mucks up the docket. And what y'all really need is a short answer and direction from the court. And I try to give it timely. Anything else, Mr. Elliott?
No, thank you. Thank you.
Okay. Mr. Hoffmeyer, you wanted to have the last word on your motion, requesting that the court vacate the prior injunctive order.
Yes, Your Honor. I apologize for, I take my responsibility to the court very seriously. And when things are, Mr. Elliott has made this argument in every time we've been in front of the court and in writing, citing to a rule from pre-1992 before the Supreme Court ruled in, weighed in, which said that if you don't sell in a commercially reasonable manner, then you have no balance. Then there's no balance to recover. But again,
I've read at least 3 cases that Mr. Schuyler has cited and that you have cited, Mr. Hoffmeyer.
right. But I just want to put right here, you lose the right to cover deficiency, but if the presumption is rebutted, the right to recover the deficiency remains. And so I just want to point that out, that there very much is a deficiency, whether he likes it or not. We've submitted evidence sufficient to show that we have a likelihood of success on the merits to show that there is a deficiency. And I don't want the court to be misled by this argument that he continues to make to every court. And there is a history there. That's why I get a little exercise, and I apologize. But yeah, so I also object to, and I don't think the court's going to do this, but I don't think there's any basis for the court to wait for a discovery conference that I'm not involved, even if I'm involved in it. The court should rule based on the briefs and the evidence submitted, not on a discovery conference that Mr. Elliott wants to have.
Okay, understood.
Thank you, Your Honor.
Thank you. So I'm not exactly sure who asked, but one of you asked if we could have so the way a case in front of me would normally work is the answers would get filed and then I would enter a scheduling order. Now, what I typically do is file a notice of intent to enter a scheduling order that gives y'all an insanely short amount of time to conduct discovery. And basically it says, but obviously if y'all want more time, take more time. And the idea being y'all take as much time as you need. If you think it's going to take a year for discovery, then take a year for discovery. I don't care. But the idea is don't take 6 months to do discovery and then come back and go, can I have another 6 months? And can I have another 6 months? And can I have another 90 days? And can I have another 60 days? The idea is to think meaningfully about what the deadlines are that are involved. I used to practice in federal court, and so that's what you had to do in federal court, and I really liked it. Now, admittedly, I'm not federal court, so the deadlines, when the parties agree, can be a little squishier than they might be in federal court. But at the end of the day, the scheduling order needs to be entered, and one has not been entered because of the manner in which this case came to me. And so I think at the last communication that Mr. Freehoff had was for the parties to agree to submit some sort of proposed scheduling order. I think I had from perhaps Mr. Hoffmeyer that could we perhaps discuss this issue today and get some guidance from the court? And then in aid of that, the parties submitted at least a working document. Whether it has any buy-in from anybody, I don't know. But at least
that was me.
Right.
I circulated that yesterday because Mr. Freehoff said he wanted to have something before the hearing. And so I circulated that to the parties yesterday. And I assume everyone was preparing for the hearings. I didn't hear anything. So just to not run afoul of the court, I submitted. And I hope that I clarified to Mr. Freehoff that was something I put together based on guidance from the court and from your order on timing. But that is solely for me, just to satisfy my obligations to the court.
Okay.
But yes, you're correct. It is. I did ask for just because, yeah, I'm not sure if Mr. Bush's motion to dismiss is still pending.
I am not aware of any, hang on.
Because
So that is another
theoretically,
thing that I find exceptionally frustrating, is that this case is in a fairly advanced procedural posture, and there was a lot of discussion about whether there was or could be a stay because of the transfer, whether there was or could be a stay because of a motion to dismiss. My understanding is that the operative motion for Mr. Bush is a motion to sever, and that is not a motion to dismiss, and there is no operative stay unless the parties request one.
I think it was before the case came over, and I thought I
And
saw the thing that it was motions, but we withdrew our motion to dismiss and started discovery with Mr. Elliott. So because I thought it'd be helpful to have everyone in the room to see, when we can start. I propose 4 months from now, the end of discovery. We've been proceeding for 3 months now, but if we do 3 months of discovery, then that gives Mr. Elliott till today under your guidance to designate his expert. And I think that was fair. So I gave us 4 months with 90 days from the end of discovery for him to designate, 60 days for me, 45 days for rebuttals. But I have not heard back from anybody else on whether that's agreeable.
Mr. Elliott or Mr. Bush, did you have a chance to look at the proposed dates that Mr. Hoffmeyer submitted?
Yes, Your Honor, I did. I was in agreement with those.
Okay.
Assuming Gentian, if and when
If they come
Gentian,
into the case, then all those are going to be blown out, or I guess I should say when they come in the case. And that was one of the reasons that I agreed to let's have this conversation, because once Gentian comes in, they have a right, whether they stay in the case or not, long term, they have a right to insist on at least 6 months of discovery. And I'm sure that might be one argument in favor of severance. I don't know. But that is given that Gentian, based on my ruling today, is coming into the case and will be coming into the case effective July 31st or sometime thereafter. Based on at least an initial discussion that Mr. Bush would probably be willing to accept service on behalf of Gentian. And then Mr. Bush, I should warn you, I don't think I said at the beginning of the hearing, just so you're prepared when you see that proposed order. When I allow a party to be added, I do typically, I know what the rules are about parties not having to re-answer the complaint that are already in existence. Sometimes I do if I feel like it's helpful to the process. Obviously, Gentian will need to answer. But I wanted to make sure that y'all are aware that I don't intend to enter an order that says anything about any obligation of the existing defendants to actually answer the amended complaint, other than Gentian. So assuming that Gentian is going to come into the case, that sort of blows these deadlines out of the water, unless Gentian wishes to consent to a shorter discovery period. And so, I mean, for example, if Gentian is in the case effective in, let's just call it August, discovery would be running in February rather than November. And so that's something
If they're transferred, it doesn't matter. Like, yeah, that's the pickle we're in, because then we get an
It
extended
is.
discovery. Because I don't think we need much more discovery in our case.
Okay. What I would ask is that the parties continue to discuss with one another these dates. The case exists as it exists currently. And to the extent that the parties can agree to some sort of discovery plan that you can submit to me in accordance with my standing case management order. It may be that it has to change if Gentian comes in, if y'all want to agree to some dates that exist now. Without Gentian, if you want to agree to some dates later that and acknowledge that Gentian will be coming into the case, y'all can do that. But I need something so that I know what my deadlines are in terms of checking in and telling you when this case will go to trial, if and when it needs to go to trial. So reasonably, when do we think we could do that, Mr. Hoffmeyer?
It depends on everybody else, but if I'm prepared to stand by my order that I proposed. I haven't heard from Mr. Elliott.
Yeah.
Mr. Bush said he doesn't object, but it's subject to 3716. But I could submit that order today if Mr. Elliott and Mr. Bush are in, or you could just enter whatever I've submitted today if Mr. Elliott and Mr. Bush are in agreement.
Mr. Elliott, did you have a chance to look at the proposal from Mr. Hoffmeyer?
Just briefly, Judge, and that's an understatement, just glanced at it. I thought I was going to have 3 motions today, and I thought we were going to have a hearing on the motion to compel because it was on the original calendar. So I've been slammed with this case. I didn't have a lot of time to put in it. I didn't speak to my clients about it. So, so to answer your question, I would like to at least look at it thoroughly. I don't think I could agree to it in its form because of the new addition of a party. But I mean, I guess I could, if everyone will agree just to stretch out all the timelines to 6 months, I mean, I could agree to that.
6 months from today?
Well, let's assume, yeah, well, from the day,
6 months from August, so
Yeah.
7 months from today, Mr. Hoffmeyer.
Well, yeah, I mean, so are you talking, and this is a clarification, but when you say from August, you're talking about running it from the date that 3716 Gentian accepts or from their answer?
no, I'm talking from the date they have 6 months worth of discovery.
Right, right. I'm just asking the judge.
I'm sorry.
She was saying August, but it's like, I'm fine if Mr. Bush is fine going based on, but then he's not, yes, I mean, do we run it from, I don't want like. I
So
don't
at the
need a lot
beginning of
more-
the hearing, the conversation that we had in terms of scheduling is that I would need to touch this case again in mid-August, 1, for a discovery conference, and 2, to revisit Mr. Bush's motion to sever.
Mhm.
That will be right on or about August the 5th. And so as a result of that, what my intention is if I understood Mr. Bush in his efforts to represent his client and perhaps to join them to that motion to sever, which he had represented that he intended to do, that he would probably be answering on an expedited basis. And so I was imagining that would be fairly quickly. And I was estimating by mid-August, which would really only be about half the time that he had instead of the full time. And if he took the full time, it would still only be the beginning of September. If he acknowledges service relatively quickly, which he's indicated he intended to do. And so what I'm imagining is that Gentian would be all the way in this case through an answer or other responsive pleading by early to mid-August.
So would you want me, I could redo, if that's the case, if you want me to redo the order that I did, the 14th is a Friday, the 17th is a Monday. I could run, and then 21st is the following Friday. I could recirculate the order with 6 months from the 14th of August.
It sounds like Mr. Elliott's willing to agree to that. It sounded like, am I correct, Mr. Elliott, that if we were talking 6 months from August for the end of discovery, and then the remainder of the remainder of the deadlines flow from that date?
Would it be helpful if I shared your proposed the date so that he has something to look at? I can do that real fast if it's helpful.
Sure.
Okay.
Yes, Judge, you heard me right. 6 months, and then after that, the motions and mediation and all that stuff. So yes, that's what I meant.
Okay. Okay. So, and then of course, Mr. Bush, you're hopeful that you don't have a dog in this fight and that it doesn't matter to you, but for now it will still matter to you, Mr. Bush.
Your Honor, just to follow up, we do plan on behalf of Gentian filing our answer and joining the motion to sever immediately so that when we reconvene with you sometime in August, that is right for all parties.
Okay. Now understand, I am not legally obligated to have a hearing on that motion to sever. And so if you want a hearing, you need to let me know that you want a hearing. Otherwise, it's my intention to wait until Gentian joins it and then look for Mr. Elliott's response in opposition and then rule on it. And then separately, we would be having a discovery conference regarding discovery issues in the case.
I understand.
So if and full disclosure, even if you ask for a hearing, I might still tell you no, because I'm not legally obligated to give you one. But if you need a hearing, if you think that would be helpful for some particular reason on this issue, then y'all can ask and let me know. But I did want to be clear. You should not necessarily be expecting that we will be having a hearing on that motion. I'm just expecting that I will act on it as quickly as I can after it is ripe.
I understand. Thank you, Judge.
Thank you. And so, thank you, Mr. Hoffmeyer. What I'm anticipating is if in a quick look at my calendar, if we were looking at mid August at a time as a time when Gentian would be fully in the case, 6 months from then is February of 27, and everything sort of flows from that. I can tell you that if your discovery deadline is in February of 27, you would be looking at a trial date in either April or May of 27. And I can also tell you that my pretrial conferences are always the first week of the month, and my civil trial calendar is always the last week of the month. And so once you tell me when your discovery cutoff is, I can tell you when your trial week is. And we can go from there.
Well, if we're all in agreement to run it from, say, August 14th, you want to go ahead and give us a trial, then I can put, because I think I did this wrong with the pretrial conference and the trial, the way I drafted it. So I can go ahead and fill those in, and then I can adjust the others accordingly if we end in mid-February 2027.
Yeah, I mean, I don't mind. I can tell you that if you can send it to me with the let me hang on. Let me pull up my calendar.
Do you want me to send it to you with the pretrial conference and trial blank?
Yes, you can
Okay,
just leave them
that'd be
blank.
great, okay.
What it will say, I can tell you right now. For example, if your trial date is, if your pretrial and trial are going to be in April of 2027, what it will say is week of April 5th, 2027, and then your trial week will say week of April 26th.
Okay.
And you'll go from there. Like and like I said, my trial days are usually that Monday, but sometimes they're that Tuesday, and we'll go from there. But I
Okay.
can also tell you that my pretrial conferences are almost always on Thursday of whatever week I tell you your pretrial conference is. So
I'll
Okay.
adjust these and recirculate it just so Mr.
Mhm.
Elliott and Mr. Bush can see it. And then I'll include Mr. Freehoff, and they can just respond to him if they approve, and then you can y'all can do whatever you want to do with it.
And side note, that probably doesn't need to be even on the record, but where did you get this draft? Is this the template you pulled from the website, or did you get it from like one of your partners or something?
I got it from Freehoff, I think.
Okay, because I don't think this is the most current version of it. I'll fix the parts of it I don't like. But I noticed
So-
I've recently been changing a number of things, and it's because it's supposed to be 3 days and it's supposed to be day of and a few other things. So I'll just talk with Mr. Freehoff if he's using an old version. I don't think it's the one on the website, or maybe I just haven't updated it.
Yeah, so I got the Word version I got from Mr. Freehoff, and then I went online to get the 90 days before, 60 days before, 45 days before. That stuff is online on the PDF from a PDF on your from the pretrial order or the civil litigation order.
Yep, I'll need to check that and make
The
sure it's
overall bit was the Word document, but it was blank. It just said plaintiff expert disclosure. So
okay. Okay, we can go back on the record now, Madam Court Reporter. Thank you. Anything else? So if I were to task you guys with submitting something agreed by tomorrow, is that doable, or do I need to give you another week to do that?
What do you say, Mr. Bush? Is tomorrow good?
Tomorrow's fine.
can I just send it? Would you guys be okay if I just send it, since we're pretty much in agreement? I'm just going to run. I can just send it, include Mr. Freehoff, and you guys can just object or not object.
That's fine with me.
Okay. That way, if it doesn't fail to, if no one objects, then he can just.
And that way we can get it on file for you as quickly as possible.
And I will leave those two blank.
Yes, sir. And
Okay.
I will finalize it and get it on file for you guys.
Okay.
Anything else that the parties need from me for today?
No, thank you, Judge.
Mr. Elliott is going to withdraw the emergency motion, correct?
That's what I understood, and he was also going to send me a proposed order allowing him to file an amended complaint, naming Gentian on or before July the 31st.
Okay. And then while we have everybody here, because sometimes it's hard to get people, this doesn't need to be on the record, but with respect to the inspection of the property, Mr. Elliott's trying to get to it. Mr. Bush filed an objection. I just want to make sure I know when it is so I can be there. Can we have a conference sometime to schedule a a visit down there so we all are on the same page? I'm asking Mr. Elliott and Mr. Bush.
Yeah, well, I really think the ball's in Mr. Bush's court. If he will work with us, that's the whole reason why we can't inspect. So if Mr. Bush says yes, then absolutely.
Yeah, because I'd just like to have like it's all on the same page. So I'm happy to have a phone call or something later so we can all plan on being there at the same time.
Yeah, I just think the ball's in Mr. Bush's court.
Okay. If I haven't heard from you guys in a couple of weeks, I'll circulate a calendar invite asking for a conference.
Okay.
All right.
The
Thanks,
only other
Judge. I
piece of
appreciate it.
That's okay. Before you go, the only other thing I will tell you just is that I try really hard to act timely on motions that are pending and right before me. And so the best piece of advice I can give you is do not make the mistake that some lawyers have made, which is that if a response to a motion is due, it's due. And I mean, the law says 30 days plus 3 days for mailing. That's 33 days. And I've been known to issue orders on the 35th day. So if you guys have an agreement that somebody's going to take more time to answer, that's fine. But you guys got to tell us, because otherwise I might enter an order while y'all are all in agreement that can wait. If y'all are withdrawing motions, I need you to tell me that you're withdrawing motions so that I don't act and spend time drafting orders that don't need to be drafted. And so, like I said, I try really hard to act, if a motion is ripe, I try to act within, if it's 33 days, I typically try to act and rule on a motion within 60 days. So the window from that 33rd day that somebody's filed a response until the 60th day. And so just a piece of advice.
Thank
Okay.
you.
Thank you.
Thank you all very much. Have a good day.
Do you prefer
Thank you.
stipulations or?
I'm
like,
sorry?
Do you prefer us to put a stipulation on the record or just send an email to Mr. Freehoff?
It needs to be in the record, I think, because otherwise we don't know. It's hard to keep track of anything if it's not in the record. And so it should be something very simple, but yes.
Yeah, we
typically
stipulate
needs
that
to be a
Mr. Elliott has
stipulation.
additional 30 days to respond to X,
Right.
Y, and Z. Okay. All right.
Exactly. Anything else?
Not for me. Thank you, Your Honor.
Thank you, Judge.
And sorry, Madam Court Reporter, if she's, yeah, there's, sorry.
Thank you all.